18th. When? 19th. Okay, 19th.
What do I click? Got it.
19th March, my lord.
Case mentioned, defendants are to file their defense to the suit. Pleadings are settled before the next adjourned date. Case adjourned to 19/3/2024 for hearing.
As copies.
First
almost
investigation.
Case number 2.
Thank you.
NICN LKJ 15/2023. Claims Mr. Odoma David Abu and 1 Kogi State College of Education, Ampa. 2 the Provost, Kogi State College of Education, Ampa. 3 the Registrar, Kogi State College of Education, Ampa. 4 the Chairman, Governing Council, Kogi State College of Education, Ampa. Parties absent, my lord.
Appearances.
With profound respect to this honorable court, I am M.A. Omada, holding the brief of G.R. Oshodi.
M.A. Omada.
M.A. Omada, holding the brief of G.R. Oshodi. Appearances for the claimant.
Any other appearance?
May it please the court, my name is J.Y. Aldo. My appearance is for the defendant. Now, we have a preliminary objection before my lord.
When was it filed?
It was filed on the 27th of November, 2023.
Mr. Omada, are you in receipt of the notice of primary objection?
Yes, my lord.
Have you reacted to it?
Yes, my lord.
When did you do that?
It was done, my lord, on 16th of December, 2023.
I think I should.
15th of December or 20th of December?
Dated 16th of December and filed 20th.
My lord, even though we have a PO before you, we are considering ADR, and we've communicated this to the council on the other side.
What do you mean?
We want to resolve the issue outside the court.
Sir.
Learned Counsel, Aldo Esquire. Aldo Esquire.
Yes, my lord.
You said you are considering what? I don't like the manner of your dressing. In the courtroom, I don't know what you put on under your collar. It's not proper.
Violence.
Whether or not it's a trial, it's not proper, okay?
Yes, ma'am. I'm sorry, ma'am. My lord.
You said you are considering amicable
ADR.
settlement.
Yes, ma'am. Yes, my lord.
Mr. Omar,
Yes, my lord.
Omada, any
Yes, my lord.
objection to this?
No objection, my lord.
So what date? What registrar?
19th March, my lord.
Nineteenth March. Is it convenient for both of you?
Yes,
and are you
my
sure
lord.
by then you would have been able to resolve the matter?
Yes, my lord.
Yes, my lord.
Of March.
19th, my lord.
19th.
Yes, my lord.
It is in the light of the above settlement out of court moved by the defense counsel that parties are further encouraged to resolve this matter and report back to court on 19th of March 2024.
As the court process.
Please.
Next case.
Case number 3, NICN LKJ 06-2022 between Honorable Fonsho Emmanuel Olorufemi and 5 others and Kababonu local government and another. My lord, parties are absent.
Appearances.
With profound respect to this honorable court. O.W. Obaido. My lord, appearing with me is B.L. Abba. Abba is A-B-A-H. Our humble appearance is for the defendants, my lord.
Any other appearance? No appearance for the claimant. Any report? Settlement? Any report of settlement, Mr. Baido? You have muted your phone. You have muted it. Unmute it.
Sorry, my lord. Sorry, my lord. Yes, my lord. Since the last day, the claimants informed the court that they will want a move for settlement. We have not seen them again. We have not heard from them. No move for settlement has been made, my lord. Unfortunately, he's not in court today. My lord, we will be asking that we will give another trial to settlement. However, we want it to be for report of settlement or for commencement of hearing. If report of settlement fails, my lord.
Court registrar, what date?
20th March, my lord.
Case adjourned to 23/2020 for definite hearing. For report of settlement. Notices are to be served on the claimant proof to be filed.
At court, please. We are grateful, my lord.
On the next case.
Case number 4, NICN LKJ 27/2019 between Samuel Babatunde Agbaja and Kogi State Government and 4 others. My lord, parties are absent.
Appearances.
Appearance for the claimant.
CA what?
TA Olu.
If you are not addressing the court, mute your phone. Any other appearance?
May you please this honorable court. My name is Oluwafemi O Adegboyega. State legal advisor. I appear with my learned friend, V.A. Shaibu, legal officer. My lord, we appear for the first to third.
What's the name of your learned friend with you?
V.A. Shaibu. V.A. Shaibu.
Legal officer.
Legal officer. My lord, we appear for the first to the third defendants applicants.
Any other appearance? Any other appearance?
Respectfully, my lord, O.W. Obaido appearing with B.L. Abba for the 4th and 5th defendants, my lord. Defendant applicant. My lord, the matter was adjourned today, slated today for hearing of defendant application. Subject to the convenience of court, we are ready, my lord.
Lord,
When did you file the application? When did you file the application, Obaido Esquire?
My Lord, the fourth and fifth defendant filed on the 28th of November, my Lord. Counsel to the first to the third also has a similar application, my Lord.
So who filed first?
my Lord, we filed first.
When?
We filed on the 20th of November, 2023.
Go ahead, Mr. Olowo. Have you reacted to the application?
We will be reacting on point of law, my lord.
When did you file it?
We didn't file it. What we do is the legal report to reply to
Eh?
we have oral reply, my lord.
Such practice are not acceptable. You have been served since November last year. So why didn't you file your reply on point of law? Hmm?
We are sorry to make it by the leave of court and oral reply. This is a point of law.
Have you filed your respective final addresses?
My lord, I have filed demand.
Eh?
I have filed demand.
When did you file?
I filed.
The defendants are supposed to file first.
I waited for them. I called the first to third defendants counsel. And he initially asked me to wait for him. When I saw that he was not responding, I called him again.
Mr. Obaido, mute your phone. Mute your phone. Adegbega, mute your phone. Go ahead. Mr. Olowo, unmute your phone, Mr. Olowo.
Hello.
And talk to the court.
Very well, my lord. It was when there was no response from them that I decided to file.
Mr. Adegbega, why haven't you filed? Mr. Olowo, mute your phone. Mr. Adegbega, mute yourself and talk to the court.
My Lord, our final written address is not ready, but my Lord, we will file on Friday.
When were you supposed to have filed?
My Lord gave us 21 days to file.
From
the 24th of November, my Lord.
how many days now?
My Lord, we're already out of time.
Mr. Obaido, why haven't you filed?
My Lord, we are sincerely sorry for that. I had been laboring under a wrong notion. I was thinking because we've not taken the motion, we will not have a right of audience. But having discovered that that will not be true, I immediately went and prepared my addresses, my final address, and even the motion. It's even in court right now, my lord. I later spoke with my colleague, the claimant, and informed him of my predicament. I intend to file that immediately as we leave the court here, my lord. It's before the court this morning.
Mr. Adegbega, go ahead and move your application.
My lord.
And in the meantime, I give you 48 hours to file your final written addresses. Serve an advance copy on Mr. Olowo. Mr. Olowo, if you intend to file another one, you can file one after receiving the defendant's final written addresses.
As the court is.
We are most grateful. We are most grateful, my lord. My lord, our motion is dated the 20th day of and filed on the same date. Mr. Obaido. My lord, the motion is brought one of the rules of this honorable court. My lord, the motion prays in setting aside the order of this honorable court contained on the 18th day of October 2023. My lord, the grounds for are contained on the face of the motion paper. There are 8 grounds in all, my lord. In support of the said application, my lord, is an affidavit of 5 paragraphs. Attached to the said affidavit, 2 exhibits. One, an exhibit KGSG2, filed. Also filed is a further and better affidavit in support of the motion on notice. Was deposed to and filed on the 24th day of November 2023.
24th. Deposed to by who?
Deposed to by Sunday Shatter. Sunday Shatter. It was of November 2023. My lord, attached to that affidavit is one exhibit. As exhibit KGSG3.
Sunday Shatter. So who is Sunday Shatter?
My lord, Sunday Shatter is a
HEO, not Oluwafemi Adegbega, right? On whom the court gave an order to pay costs personally.
My lord, the Supreme Court in, I believe, Akinlade, and I can get the citation. Counsel should avoid personally deposing to affidavits that will be used in the same matter where he appears. And that is why we have...
This one has to do, this has to do with a matter or an application that affects the council personally. So it is the council that is supposed to depose to that affidavit, stating facts, not through someone else, not through an HEO, but the council who is affected by the order of court personally, because it was a personal cost awarded against counsel, not against the defendant. Go ahead.
As the court please.
Go ahead with the application. Is that all?
My Lord, we rely on all the paragraphs of the affidavit and all the exhibits attached therewith, also filed in support of the application is a written address which was also filed on the 20th day of November 2023. My Lord, we adopt the said written address as our oral submission in respect of the motion and in urging your lordship to grant the said motion as prayed, my Lord.
Very well.
We are most grateful, my Lord. My Lord, if I may say one word, my Lord, and that is to the effect that the facts as to the reason that necessitated this application are not in doubt. It is the law that has made us to bring this application. So that is why we have brought this application. The facts are not in dispute. We urge your lordship to consider our address and grant the prayers and the motion as sought, my Lord. We are most grateful.
Very well. Mr. Olowo. Unmute your phone.
Very well, my Lord. We are in receipt of the motion paper dated 20th of November 2023, my Lord. And filed on the same day. Together with the further and better affidavit filed on the 24th day of November 2023, my Lord. My Lord, a simple reply is that the power of this court to impose personal costs on counsel is never to be doubted. As stated in Order 55 Rule 7, Bracket 3 of the rule of this court.
Rule what?
Order 55 Rule 7.
Very well.
bracket 3, my Lord.
Sub-rule 3.
However, my Lord, we respectively say that the contention in the present claim under consideration is the entitlement of this honorable court as an impartial arbiter to a cost, my Lord.
Entitlement of this court
Very well, my Lord. To a court.
as an arbiter.
Yeah, very well, my Lord.
To do what?
To cost. Respectfully, my Lord, we are in short or a want of authority as to the entitlement of this court to a cost. Since we have no authority to substantiate our position if otherwise. Nevertheless,
the rules of court, is it not an authority? You are talking about authority only in respect of case law authorities?
The rules of court, my Lord, gave some conditions under which a cost may be, personal cost may be awarded. And it's not for the court, my Lord. It's supposed to be for the party.
For the part, very well. So you are saying that I should ask that the cost be paid to you?
Nevertheless, my Lord, we are open to the
tutelage
of
government. No, listen. What you're saying is that cost should go to you, that is the claimant, and not to the court, not to the TSA account of the court.
That is how we respectfully understand it, my Lord.
Okay.
Nevertheless, my Lord, we are open to the tutelage of this honorable court to enriching our knowledge. Hence, we shall leave the rest to this honorable court. We are most obliged, my Lord.
Very well. Mr. Any reply on point of law so that we move to Mr. Baido? You have muted your phone. You have muted your phone.
My Lord,
I'm still with Mr. Adegboyega.
My Lord,
on point of law.
On point of law, my Lord, I agree with my learned friend that though the rules of this honorable court, which he has cited, stipulates the situation or circumstances where your lordship can award personal cost against counsel. My Lord, I also agree with him that the rules do not provide that such cost is payable to the court.
What?
Such costs
I'm listening.
My Lord, my only point of disagreement this court is that, my Lord, the learned counsel on the date the order was made no application for cost. He conceded to the application for adjournment. He conceded to the application for adjournment and only made an appeal to your lordship to make it the last time that an adjournment will be granted on the basis that our witnesses were not in court. So, my Lord, he is not entitled to the said cost as he has not prayed for it. He conceded to same. We urge your lordship in the light of our submissions in the motion notice to grant our prayers as sought in the motion on notice.
Mr. Abaido. Mr. Abaido.
Yes, my Lord.
When did you file your application?
My Lord, we filed our own motion on the 28th day of November, 2023. My Lord?
Please mute your phone if you are not the one addressing the court. Mute your phone.
Is there somebody else talking outside?
Mute your phone if you are not the one addressing the court. Go ahead, Mr. Biden.
My Lord,
when did you file your process?
Motion is brought pursuant to Order 17, Rule 1.
When did you file it? When did you file the
on the
motion?
28th day of November, 2023. Dated and filed the same day, my Lord. My Lord, the application is praying for an order setting aside the order of this honorable court delivered on the 18th day of October 2023, awarding personal cost of 100,000 against counsel to the fourth and fifth defendants, which was to be paid to the honorable court's revenue account within 48 hours. My Lord, the grants for this application are contained on the face of the motion paper. This application this application is supported by an affidavit deposed to by one Irene Chine Duke, a legal practitioner.
Deposed to by one.
Irene Chineye Duke, a legal practitioner. My Lord, we rely on all the 24 paragraphs of these affidavits.
Go ahead.
My Lord, this application is supported by written address in compliance with the rules of this court. We adopt same as our argument in support of this application. My Lord, by way of a brief further
Except if you have any authority
Sorry,
you
my
want
Lord.
to, except if you have any authority that you want to comment to the court.
Yes, my Lord, we just want to draw. Sorry, my Lord, I just want to draw my Lord's attention to the rules of this court. Order 55. Rule 7 sub 3. My Lord, the provisions read thus, my Lord.
The one that Mr. Odowo cited, the same as
yes,
the one
Lord, I just want to cite the beginning part of it, my Lord.
The court will read it.
As the
because
court,
I have
please.
other matters, and I'm going to give a bench ruling on this.
As
so
the court, please, my Lord. My Lord, off record, my Lord, we just want to state something else, my Lord. My Lord, having stated the law expressly in our address, we also want to appeal to the conscience and the mercy of these courts. My Lord is like a mother to us as counsels, and personally, since 2019, that I've been appearing before my Lord consistently. I want to say that my Lord has been like an inspiration to my legal practice, a major reason why I've gone this far. And my Lord is like a legal mother to my legal profession. So, my Lord, I want to also plead with my Lord to, even in consideration of the economy of the country at this moment, and to also invoke that motherly compassion and the mercy dimension of the court in writing this ruling, especially on the fact that the defendants have, fourth and fifth defendants have done their case diligently. And if the record of the court to shows,
they even found their final written
we are grateful, my Lord. We are grateful, my Lord.
And to crown it up, they filed their final written addresses within time. So that they are very diligent, right?
We are grateful, my Lord.
Very well. Who are those talking there? Court registrar. Mr. Obaido, mute your phone. Who are those talking?
My lord, is not in the open court. I think it's from the control room, the host, the office there, sir. My lord.
Okay, okay. But
Abuja ni Adeniyi àbí Kaduna? Kaduna ṣebí Kaduna lè fi design ẹ̀. Ó yá na go live. Èmi ò kí fi anything sí tèmi o, nígbà máa ń go live báyẹn mi ò fi anything sí rí o, níbo ló tún rí style lè. Go live kó copy link yẹn sí group torí site yìí ò ṣiṣẹ́. Kó fi Kaduna Sunday festival time bá fẹ́ register. Ẹ má post anything sí group o. Ṣé pé mi ò post lẹ́nu kò sí nǹkan tí màá wò. Copy gbogbo link yẹn post ilé. End ẹ̀fà tá à ń pè mí. Hello, sir. Mo wà ní system Títí ló ń pè mí lọ́wọ́. Wọ́n ti mute ẹ̀.
Mr. Olowo.
My lord.
Yes, what's your reaction to?
We'll be adopting our reply.
Okay.
Except that we just want to add that we are not opposing the magnanimity of my Lord to favorably consider the plea of the council. Since he has said he will appreciate the largesse of my Lord, considering the economy of this country, and more so that what my Lord aimed at has been achieved. We are most obliged, my Lord.
Respectfully, my lord.
I'm already writing my ruling.
My lord, can we also we should also not fail to appeal to your lordship. As my learned friend had said, the purpose for which your lordship awarded the cost has already been achieved, in that our witnesses have come to court and have testified.
I'm actually writing my ruling. So my please Lord, don't interject.
As a corporate, we're most grateful, my lord.
I've heard both learned counsel, A.O. Adegboyega and O.W. Abaido, on whom the court has awarded costs of 100,000 naira each for their respectful conduct in the face of the court on the 18th of October 2023, leading to the award of punitive costs. Punitive costs against counsel personally. It is pertinent for me to state here unequivocally that the court, in its bid to ensure that justice is done to parties, to ensure that parties respect and upholds the sanctity of the court, has inherent powers. One of such inherent powers is to punish any errant party or parties or counsel who may have impugned its integrity or sanctity. It is evident on record that since the resumed hearing of this case on the 23rd of January 2020, that is 4 years today, neither the first to third defendants nor their counsel appeared in this case. They equally failed to file their statement of defense until the 26th of May 2023, after the court has issued several hearing notices served on them. It took the first to third defendants more than 3 years to file their defense to this suit. All this was allowed by the court in its magnanimity and to ensure the obedience of the ad autem partem rule. In the same vein, it took the fourth and fifth defendants 2 years to file their defense to this suit. On the 26th of May 2023, counsel for all the parties were in court, and they all voluntarily consented to the 17th and 18th of October 2023 date for commencement and conclusion of trial of this case, the court having given the defendants ample opportunity to defend their case. Both defense counsel were in court on the 26th of May 2023. Sorry, I'll take this again. Both defendants' counsel were in court on the 17th of October 2023, but their witnesses were not in court. The claimant testified for himself as CW and was cross-examined by both defense counsel. Afterwards, after the fact that he was recalled as CW, having first given his testimony on the 23rd of March 2023, was cross-examined by counsel to the fourth and fifth defendants and was discharged. Adegboyega Esquire filed an application for a recall and the court obliged. Adegboyega and Abaido of counsel for the defendants did not tell the court that their witnesses will not be in court on the 18th of October 2023, being the next date set down for the defense. On the 18th of October 2023, Adegboyega of counsel, as stated on record, informed the court that his witness is on official duty and so could not come to court. The court then asked if the court proceedings of that day is not an official one. He answered in the negative. On his own part, Abaido Esquire of counsel to the fourth and fifth defendant said his witness will not come to court because he is busy. It was at that point that it became clear and evident to the court that both counsel are taking the court, the course of justice and the rule of law for granted. Both counsel, by their conduct, exhibited a high level of disregard, disrespect, and impunity to the court. To the court, it was at that stage that the court decided to exercise its discretion, act in its inherent powers to stop such denigrating of the court by counsel. God forbid the day that counsel in his bid to have his way at all costs would be allowed to conduct himself in such an uncanny manner before the court and be allowed to go scot-free. To allow that is to pull down the whole essence and the pillar upon which justice stands in this clime. Naturally, respect to the constituted authority due to courts are the main pillars that oppose the cause of justice together. It is in the exercise of the inherent powers of this court and armed with the provisions of Order 55, Rules 1 and 7, Sub-Rule 3 of the Rules of this Court 2017, that awarded personal costs against counsel as stated above. It is obvious on record. Allow the defense to call their witnesses, cross-examined by claimant, and they close their respective defense. The court gave order 45 of the rules of this court for parties to file their FAR 2023. Only the claimant counsel had Adegboyega and Obaido Esquire had failed to file their respective final written addresses. This also goes to show the depth of disregard and ineptitude of counsel to the court, ditto the rule of law. Today is 60 days since the last adjourned date. It is in the light of all stated that I refuse both applications filed by both learned counsel for being unmeritorious. The affidavit in support of the application equally speaks to the unseriousness of both counsel to the application. I say this in view of the fact that the cost in question was awarded against counsel personally, and the affidavit in support of an application seeking for the exercise of the court's discretion in their favor ought to have been deposed to by each of the counsel personally who are seized of the facts leading to the application, and not by other persons. Does not regard sentiment. The court will, in its magnanimity, once again, and in view of the plea by counsel, review the amount of costs awarded to 50,000 naira each. Consequently, Adegboyega Oluwafemi of counsel to the first to the third defendants, and O.W. Obaido, counsel to the fourth and fifth defendants, are to pay personal costs of 50,000 naira each to the government account of this court within 48 hours, failing which they are to be held of being in further contempt of this court. I so rule. Court registrar, unmute your phone. Both counsel are to file their final written addresses within 7 days. So give me a date for adoption. Mr. Olowo, would you want to withdraw the final address already filed?
I wouldn't know, depending on what, when I receive their own final written address.
Okay.
My Lord, February.
Give me a date in February.
Yes, my Lord.
For definite
adoption. 13. Is it?
13th of February. 1-3.
Very well. Both counsel are to file their final written address within 7 days, serve an advance copy on the claimant's counsel, who is at liberty to either discountenance his final written address already filed.
Let's go places.
and filed another one.
Escort places.
13th.
Yes, my lord.
That date is convenient for all parties. By consent of council of all, by consent of all council, case adjourned to 13/2/2024.
No, sir. Stop. My lord, I'm before I got two on that day.
Something you can just take online from that data. It's something you can even take online from there.
Call the next case. Court registrar.
My lord.
Call the next case.
Case number 5, ICM LKJ 33M 2023 between Etu Sunday Paul and Kogi State Government and 3 others. My lord, judgment creditor is in court.
Appearances.
Please, my lord. I am here, Onoja, appearing with S.O. Adam and F.O. Osman for the judgment creditor applicant respondent.
Any other?
We propose to my lord. Stanley E. Atuli, Deputy Director, Minister of Justice, my lord.
E. Atuli.
Yes, my lord. Stanley E. Atuli.
Deputy Director.
Civil litigation.
Deputy Director what? Civil litigation.
My lord.
Very well.
Justice.
Kogi Ministry of Justice.
Yes, my lord.
Very well.
Appearance for the debtor applicants.
Any other appearance?
With profound respect to my noble lord, I am
Please, if you are not addressing the court, mute your phone. Go ahead.
I am MP Omada. My head appearance is for the 2nd and 8th garnishee. Access Bank PLC and Unity Bank.
And Unity Bank.
Yes.
Any other appearance?
Hey, please, this already for SS Uda. SS Uda. SS Uda. UDAA Uda. I'm for the 3rd garnish. Yes, my lord. United Bank for Africa PLC.
Any other appearance?
May the court be pleased. A.E. Ebeneki. A.E. Ebeneki. For the 9th garnishee.
Any other? Any other appearance?
Respectfully, my lord. My lord, I'm B.M. Musa. I announce my appearance for the 5th Garnishi Bank.
Polaris.
Yes, my lord. I also hold the brief of A.O. Jonathan for the 6th Ganishi Bank.
Any other appearance? Any appearance for the 7th, 9th Ganishi?
9th Ganishi, A.E. Ebenehi.
Okay, who is for the first? For the 1st and 7th Ganishi? Neil. Neil for First Bank and Eco Bank. And Heritage Bank. Mr. Onoja. Mr. Onoja, unmute your phone.
Yes, my lord.
What do you have before the court?
7th of the 7 Ganishis have filed the affidavit to show cause. 7 out of 9 have filed the affidavit to show cause. And the judgment debtor have a notice of preliminary objection.
Is there any sum in the already filed affidavit to show cause?
Yes, 3 of the Ganishis have more
Which
than
are
enough.
which?
The 3rd Ganishi, the 8th Ganishi, and 9th Ganishi.
The 3rd,
8th,
8th,
and 9th.
and 9th Ganishis.
Yes, they have disclosed. They disclosed reasonable sum to defray the judgment sum. In the circumstances, my lord. I'm coming.
So now you said the judgment debtor filed a notice of preliminary objection.
Yes, my lord.
Have you reacted to it?
Yes, my lord. I've reacted to it.
When did you file your?
I was served on the 17th and I filed on the 18th of January 2024. Counter affidavit and reply. Our written address.
Very well. Mr.
Yes, my lord.
Are you in receipt of the reaction to your notice of preliminary objection filed by the Judgment Debtors Council? Judgment Creditors Council?
Yes, my lord.
Okay. When did you receive it?
Served on the 18th.
My lord, it was served on the 18th. Was it 19th?
Okay. So it's right for hearing.
Yes, my lord.
Yes, my lord.
Go ahead and move your application.
I'll stop, please. I know we have a primary objection dated the 15th day of January 2024 and was filed on the 16th day of January 2024. Yes, my Lord, our prayer on the primary objection is one that the court lacks jurisdiction to hear and determine this garnishing proceeding. My Lord, the application, our prayer is contained on the face of the paper.
Very well.
1 to 4.
Yes.
My Lord, attached to the primary objection is an affidavit. 6-paragraph affidavit deposed to James Sunny, the litigation registrar in the Ministry of Justice, my Lord. We are all the paragraphs of the affidavit. My Lord, in line with the rules of this honorable court, are the annexures. Exhibit MOJ A, that is the ruling of this honorable court delivered on the 15th day of June 2022. The appeal, application to Court of Appeal for leave, filed on the 16th day of February 2022 from OJ B. Hello, MOJ C is a proposal letter dated 1st March 2022. We rely on all the exhibits, and to it is our written address in support of our primary objection, my Lord. We adopt the said written address as being our argument in this case. Urging my Lord to strike out the guarantee proceeding for lack of jurisdiction. My Lord, the judgment creditor filed a counter affidavit with respect to a plenary objection. And we are saying, not minding the fact that the case of CBN and interstellar communication cited by the Learned Counsel, we are objecting to the fact that the consent of the Honorable Attorney General was not sought, reason being that parties have gone beyond the issue of the judgment that was delivered and will enter terms of contract, terms of agreement that was taken as being the judgment, ruling of this Honorable Court on the 15th of June 2023. Parties were stopped from proceeding to court. My Lord, the judgment creditor was reinstated.
Is this legal argument or fact? No. Sorry, my Lord.
My
I'm
Lord,
objecting to this.
There has to be a reply
at court pleases.
on point of law.
As court pleases. He was reinstated and he has been receiving his salaries all this while.
This is not point of law.
My Lord, we equally stated with respect to the judgment creditor that wherever there's any issue, he should feel free and have recourse to the ministry. So in this regard, we are saying that the concept of the Attorney General must be sought before bringing this.
Very well.
On that ground, we are saying that this court lacks jurisdiction for the fact that the terms of settlement contains parties has to abide by it, by what is contained in the terms of.
So have you abided by your own side of the coin, of your own agreement?
Yes, my Lord, very well.
Have you paid all the arrears?
Yes, even the arrears of rent, we were giving the guideline on how to go about the money. It's his entitlement, definitely.
But you haven't paid.
My Lord, he has not.
So you should be waiting. You should be waiting. Since 2017, you should be waiting.
No, my Lord, what is there is that what we said is if the economy is buoyant enough, and he has not shown to us that yes, there's something on ground to make sure for us.
The bank has disclosed 5 billion. So the economy is over.
Very well. Mr. Onoja, go ahead with your rest.
Thank you, my Lord. My Lord, in opposition to the purported preliminary objection, the judgment creditor applicant has deposed to 20 paragraph counter affidavits.
On the 18th of January. Mr. Onoja. Mr. Onoja, I can't hear you. Unmute your system.
Thank you. May with the kindness of court rely on all the paragraphs of the counter affidavit of 20 paragraphs.
Go ahead.
And by urging your lordship to discountenance the purported preliminary objection of the judgment debtors.
Did you file?
Yes. In compliance with the rules of this honorable court, there is a written address of counsel in opposition to the purported preliminary objection. And we seek your lordship permission to adopt same as our argument by urging the court to strike out the preliminary objection. This CBN versus Interstellar does not recognize what my learned friend now put forward to the court as reply on point of law. In effect, that is not reply on point of law. This is because AG is a party in this case. They were saying that the judgment creditor applicant did not disclose facts to this honorable court. All the facts are listed in Exhibit A to G in the expert application. And the same facts that are before the court are what are next to their purported preliminary objection. No fact was withheld. The terms of agreement was when fund of the state government is improved, the banks now just disclose over 5 billion naira of the state government by those three banks. What the applicant is looking for is just only 6 million. How then do we measure the buoyancy of a state government that has lying waste over 3 billion naira? Coming back to court was at their own initiative. They asked the judgment creditor to follow up diligently to see when the state government purse will be buoyant. The accountant general had told him there is money. Approach the third and fourth defendants to do a differential so that your money can be paid. They turned it to hostility by a series of queries. Those facts are before court. They are the one that break the camel's back. They are the one that destroy the terms of the agreement. So what consent again do you need anybody to seek? Nothing in law. So how do we measure 3 billion to 6 million? Putting the cart before the horse. So, there's no objection before your lordship. I want your lordship to strike it out outrightly. May please court. My lord, we have now replied to you on point of law, my lord, my lord. Somebody should put off his phone now. Mute your phone, please. My lord.
I'm writing my ruling.
As God please. Mute your phone, mute your phone.
Court's ruling on the notice of preliminary objection. I've heard both learned counsel in the argument for and against the notice of preliminary objection filed by the judgment debtors. I've equally perused the application and submissions in respect of same. It is on record that the court delivered its main judgment in this case since 28th of September 2021. The defendants, including the Office of the Honorable Attorney General and Commissioner for Justice, Kogi State, were parties to the suit, and counsel in the Office of the AG and CJ conducted trial of the case, specifically one H.E. Yusuf, the Solicitor General and Permanent Secretary, one M.A. Opanachi, an FMCD, all of the office, they are all officers of the Office of the Attorney General and Commissioner for Justice, Kogi State. They conducted trial from commencement and conclusion of the case and judgment delivered. After waiting for more than a year without compliance to the judgment of the court, the judgment creditor filed a suit against the judgment debtors, including the Office of the AG, in order for the enforcement of the judgment. Counsel who has filed the notice of preliminary objection, Mudu Esquire, Lokoja Lanidi, all of the Office of the AG and CG, parties to the later case, agreed to resolve the case amicably. They were given the opportunity to do so, and eventually parties filed the terms of settlement dated on the 14th of June 2022, and on the 15th of June 2022, they adopted the terms of settlement, and counsel urged the court to enter seal as the judgment of the court. And same was consequently entered as the judgment of the court as per the terms agreed to by them. The sum of 6,148,000 naira agreed to by the defendant judgment debtors to be paid to the judgment creditor has not been paid since the 15th of June 2022. And according to the terms, it was to be paid when there is fund and improvement on the finances of government. The judgment debtors have not shown reasonable cause that there is no fund or that the finances of the judgment debtors have not improved since June 2022. Obviously, the judgment debtors have failed to fulfill their own part of the judgment by their failure to pay the agreed sum of 6.1 million naira to the judgment creditor. I find no merit in the notice of preliminary objection, as same is frivolous, time wasting and a ploy to further stall the judgment creditor from reaping the fruit of his judgment. I also state here that the Office of the Attorney General, being a party in this suit and having partook in the amicable settlement leading to the consent judgment, is well aware of the facts of this case and thus does not need to be informed or consent obtained by the judgment creditor before filing the garnishee proceedings. Accordingly, the notice of preliminary objection is bound to fail and thus dismissed.
Thank you, my Lord. With this ruling, my Lord.
The third.
Yes, my Lord. With this ruling, my Lord, you will apply that. We'll proceed with the other absolute.
The third, 8th, and 9th.
I will apply that the first garnishee, second garnishee, fourth garnishee, fifth garnishee, sixth garnishee, seventh garnishee, eighth garnishee, and ninth garnishee be discharged from this garnishee proceedings, leaving only the third garnishee.
No, wait. Go ahead. I mean, go start again. I apply that the.
I apply that the first garnishee.
First.
Second garnishee.
Second.
Fourth garnishee. Fifth garnishee.
Fifth.
Sixth garnishee.
Sixth.
Seventh garnishee.
Seventh.
Eighth garnishee.
Eighth.
And ninth garnishee.
And ninth garnishees.
The discharge from this garnishee proceeding. While another be made against the third garnishee. Who has received well over 2 million naira
The third Ganishi.
Yes, my lord. Has disclosed well over 2 billion naira.
UBA.
Yes, my lord. Against UBA.
When did UBA file your affidavit to show cause?
The affidavit to show cause was filed on the 11th of January 2024.
Very well.
The order removed against UBA in full satisfaction of the judgment sum contained in the order NASA of 23rd November 2023. In full satisfaction of the judgment sum of 6,148,000 naira. And
Third Ganishi, any objection?
No, my lord.
Counsel for the third Ganishi is SS Uda.
Yes, my lord.
There's nothing.
Yeah.
Who can't hear? Listen.
Yes, I just realized I muted myself.
God bless you.
The first, second, fourth, fifth, sixth, seventh, eighth, and ninth garnishes are discharged, while the order is made absolute against the third garnishee, United Bank for Africa, to release forthwith within 48 hours the sum of 6,148,000 naira to the judgment creditor in satisfaction of the judgment sum.
Most great to my Lord. My Lord, sir. My Lord, sir. We rely on Section 86 of the Credit and Civil Process Act and Order 51 of the rules of this Honorable Court to apply for course of proceeding of this garnishee as contained in the law and the rules of this court. Order 51 Rule 1 provides for course of garnishee proceeding to the judgment creditor applicant. Equally, Section 86 of the Sheriff and Civil Process Act is couched in the same terms. We'll be asking for a cost of 500,000 naira for the cost of garnishee proceeding applied on the account of the judgment debtors. May you please call.
Of 100,000.
500,000 naira.
So third garnishee, Bank for Africa.
Yes, my Lord.
To pay to the judgment creditor 6,248,000 naira.
My Lord.
Very well. Call the next case. Call the next case.
Yes, number 6, NSDN LKJ 06-2020 between Aya Sebastian and 8 others and Kogi State government and 2 others. My Lord, parties are absent.
It's 200, it's 248, sir. I said it's 248. 200,000.
Are there appearances? Please, we are not addressing the court. Sorry. Are parties in court?
Parties are absent, my Lord.
May it please, my Lord. My name is Austin Oboni. Humbly, my Lord, I appear for the claimants.
Any other appearance?